Hey, everybody. Can you hear me okay? Really sorry to keep you waiting a couple of minutes, but I literally have just been on the docket printing things. And this was supposed to be my presentation today. I'm going to put this aside because something has just popped up on the docket that has gotten me very interesting. These are two documents. Can you hear me okay, everybody? Hi, everyone. Good to see you all. Okay, so we know that yesterday was the deadline, right? For the filing of the offers of proof relative to the alternative or alternate perpetrators that Judge Stephen J. Hippler ordered the defense to file yesterday, May 14th, in time to discuss at today's pretrial conference, which is going to start in just a few minutes. Well, there were a couple of documents that popped up on the docket yesterday. One of them was called a notice of compliance, and that usually is filed when one of the parties is complying with something. They're complying with a deadline, a court order, but the clerk of court did not say who that filing was for. So my suspicions immediately rose that those were the offers of proof. The clerk updated the docket at approximately, I think it was 2:09 p.m. Boise time yesterday. And I just checked on the docket. There have been several items that were released this morning. And that notice of compliance was not. Now, why I feel that was the offers of proof is because Judge Hippler, by operation of the April 18th order on the state's motion regarding alternate perpetrators, ordered Mr. Kohberger to file his offers of proof by yesterday to be discussed today at the final pretrial conference. So that's the only thing that we know for a certainty today at the final pretrial conference. I'm going to go over a couple of things that are usually discussed at a final pretrial conference, but I checked the docket this morning, as I do, and I now see that there are two released items that were filed after the clerk updated the docket yesterday at approximately 2:08, 2:09. It happens to be a defense second motion to seal defendant's proposed jury instructions. Okay, we see this as a defense filing. Second motion to seal jury instructions. This was filed at approximately 2:30 p.m. yesterday. So this would have been after the time that the court's docket was updated. And I'm talking about the case summary page where the clerk documents everything. And shortly thereafter, here's Judge Hippler's order sealing the defendant's proposed jury instructions, also dated May 14th, 2025. So where's the notice of compliance that we saw on the case summary page yesterday? Nothing else. There were no deadlines attached to anything else. The defense never moved for an enlargement of time or an extension of time, going to Judge Hippler and saying, Judge Hippler, that order that you rendered on April 18th, we need a little bit more time to comport with it. No extension of time, no motion for enlargement of time sought nor order entered. And I will tell you, having been up and down that docket, as I have to be, because I produce the Indie Zone podcast called Idaho versus Kohberger. We're up to episode 643. Episode 1 was page 1 of the affidavit of probable cause signed by Detective Brett Payne back on December 29th, 2022, which started everything because page 18, Detective Payne asked for Mr. Kohberger's warrant, which was signed that day, along with the criminal complaint and the order showing probable cause, and that put the mechanism in place for his arrest the following day. So the defense has never blown a deadline, and there have been multiple deadlines by court order, by their own motions that they put into effect. They have not once ever blown a deadline. So I'm pretty confident that if that notice of compliance was not the defense's second filing of the 14th of April, 2025, then they probably got it in a little bit later on, because what possibly could the defense be filing a second motion to seal jury instructions? Does anyone have any thoughts? The place to be. Hey, they live. Good to see you. Oh, I'm so happy, Yvonne. Well, here's what my mind's thinking. Could it possibly be a jury instruction on alternate perpetrator defense? Could that possibly be it? Because, ladies and gentlemen, here's where my antenna goes up. This right here, as I call it, this is the blueprint for the case. You see how much it's marked up? I printed this out October 9th, 2024, the day that Judge Stephen J. Hippler entered it. Although it's called the redacted order governing further criminal proceedings and notice of trial setting, this is the pre-trial and trial order. This outlines everything that needed to be done in this case to get to, oh, what's this? Voir dire on July 30th, started the case in chief August 11th. This, ladies and gentlemen, is everything that needs to happen, including, look at the bottom, last bullet point. What's that? Oh, it's the final pretrial conference. That's how long today's event was set for. Final pretrial conference will be held on May 15th, 2025 at 9 and may continue on to May 16th. So Hippler has set aside 2 full days for today's hearing. Now, my curiosity goes up because, of course, when I see jury instructions, second set, I return to the blueprint for the case, page number 3. Judge Hippler says here, proposed jury instructions and trial briefs shall be filed by April 14th, 2025. Objections or stipulations, that would be, because these jury instructions were all filed under seal, the state got the defense's jury instructions under seal and vice versa. They have any objections to maybe what's the burden of proof? What is the jury? How should the jury be instructed on what their role is as the trier of fact versus Judge Hippler as the trier of law? The things that the points of law that the court will instruct the jury on. Well, that all was supposed to be done in April, and it was done in April. They filed, both of them filed their jury instructions proposed April 14th, because everything's got to be run by Hippler. He makes the final decision. With the objections or stipulations, any agreement, yeah, we agree to the proposed jury instruction on what reasonable doubt means. We're going to agree to that. We're going to agree to that one. That was supposed to be filed March 31st, 2025. So what's the defense doing filing a second motion for a jury instruction yesterday, the day that the alternate perpetrator offers of proof with evidence pointing to whoever Elisa Massoff said in her response in limine, pre-trial, ruling on evidence, that's what the in limine motion means, that we have, the defense has multiple alternative perpetrator, and we will be able to meet the requirements of evidence. So if I were a betting person, that jury questionnaire that was filed yesterday under seal by operation of Judge Stephen J. Hippler's order might have been the jury instruction on alternate perpetrator evidence. Any questions? This is the place to be. Okay, thank you. I'm glad. Your heart's racing this morning, Capelli. It's a lot at stake. This is possibly the most important hearing thus far. This case has been prosecuted for 2.5 years. It started December 29th, 2022, with the filing of the affidavit of probable cause and everything that happened that day. Final pretrial conference. What is on the agenda today? Well, we have to guess because there is no written agenda. Judge Hippler used to write agendas. I know Keife has been watching the docket. He knows that when, for example, Judge Hippler set the briefing schedule for the motions in limine, for the motions, to suppress, to strike the DP, he put out schedules the day or two before. Okay, we're starting at 9 o'clock. This is what we're going to do from 9 to 10. This is what's going to happen from 10 to 11. He didn't do that for the in limine filings, as Kayfabe reminded me very correctly. So there's no agenda out for today, but we do know by operation of the October 9th, 2025 order that this is supposed to be a public proceeding. So we're only going to be on here for a short period of time. I want everybody to please sign in on the direct link to the Idaho courts and pull it up, because the more people that are locked into that link, it shows that people are interested. And I think that that is so important. Rather than me going in at this point and bringing in a bunch of people, I'd rather have 20 or 30 people log in online. And you know how to do it, right? Idaho cases of interest. It's going to bring up the Idaho Supreme Court, a web page where you're going to see multiple cases there. You'll see the Idaho versus Kohberger is one. It will take you, watch hearings live. You click on that, and it will take you to the 4th Judicial Circuit's website. It's supposed to be a YouTube channel at 9 o'clock. So we're just going to go for a short period of time here, because we're all going to go over to that YouTube channel. And if for some reason you can't log on, try a different search engine. Because when I've used Chrome versus Safari versus Bing versus, I can get on one, and I'm here in the US, I can't get in on another. But what traditionally do we see at final pretrial conferences? Well, this is usually the time. Okay, remember, it's final pretrial. Last time, the court's calling a conference of the parties in anticipation of trial. So what you typically see, what my experience has been, my research and what is, this is the time to advise the court if there's any reason in the world that would obviate, that would make not necessary a trial. And what does that mean? That means plea negotiations. Judge Smith or Jones or whoever, Watkins, we are in the midst of plea negotiations. And if successful, sometimes any negotiations, you do a civil negotiation for a settlement, that can drag on for a couple months. Civil for money. Criminal is a DP case. There's multiple interested parties involved. There's 5 counts, felonies, all 4 of them DP eligible. Counts 2, 3, 4, and 5. 1 is burglary. That is not a DP eligible count. 2, yes, that is the unaliving of Maddie. 3, the unaliving of Kaylee. 4, the unaliving of Xana. And 5, the unaliving of Ethan. That's how the counts are lined up. Don't know why they're lined up that way, but they have been lined up that way since the criminal complaint. 1, 2, 3, 4, and 5. So Judge Smith, Judge Jones, the defense and I have been in negotiations for the past couple of weeks. We're trying to come back and, okay, if there's anything that I can do to help move things along, let me know. And then maybe a couple weeks later, they go with the proposed agreement. And then the judge, remember, has to sign off on it as the trier of the law. There's other people involved. The victims may need to be, the family members need to be contacted, get their input. But remember, this is the people of the state of Idaho. That is who is bringing this action. It is not in the name of the victims. This is not a civil action. This is a criminal case that is brought by the people of the state of Idaho. That is who the plaintiff is, and represented lead counsel William Thompson versus Bryan C. Kohberger, defendant. And we always have to make mention, constitutional proclamation. Mr. Kohberger is considered not guilty of these charges, as serious as they are and as sad and as tragic as these events are. He is presumed not guilty under the eyes of the law until or unless one of 2 things happen. He pleads guilty or is adjudicated guilty by the 12 members of that future jury, with jury selection anticipated to start July 30th of 2025. Now, on the other hand, there's no plea. No, we're too far apart. This is a DP case. We've said from the beginning, the other side stood silent. He's an innocent person. Oh, here we have. Is there anything that could derail this case from getting to trial, because recall, except for change of venue, trial would be happening June 2nd. That was when the trial in Latah County was set to happen, but then we had the change of venue. Why? Why was the motion granted? What did John Judge say? Because of negative pretrial publicity. And all of the evidence that the experts presented, there were 4 of them, and they were concerned, the defense was, that Mr. Kohberger could not get a fair trial in Latah County, and that's why we are here in Ada County right now. This case should be in Latah County, preparing for jury trial June 2nd. Instead, we have the pretrial and trial order from Judge Stephen J. Hippler. The other area that you speak about in these final pretrial conference, if there's no potential for a settlement, no type of an agreement, civil or criminal, then you talk about, okay, is there anything in the world that you need the court's help with that could derail, that could delay? Is there any discoveries or a motion to compel that's sitting out there? Oh, what about, are there any alternative perpetrators? They were court ordered yesterday. They're going to be discussing it today. That's Judge Hippler's words, for discussion. So I'm not anticipating it's going to be a full-blown hearing. Anticipate that maybe there's a little bit of conversation regarding it. Wouldn't be surprised if they go into private session for that, because they're talking about people who the defense says is responsible for this horrible atrocity, not Mr. Kohberger. So that may cause them to go into private session. Maybe not. Maybe they'll speak as they do at other public hearings when they discuss things that were under seal. They might use initials. They may just say Mr. X, Ms. Y, whatever. But keep open that possibility that they may be going into private session. Does anyone have any questions? Hi, Sarah. Is that, Sarah, I know you've been keeping your eye on the docket. Has that notice of compliance hit as of yet? Last time I was on there, it wasn't. And what about the alibi? Oh, Kayfabe brings up an excellent thought. The prior alibi defense, I didn't like it. I thought it was foredoomed to fail from the beginning because it was a partial alibi defense. Hippler has absolutely no discretion to change the statute. And the statute in Idaho is the same as the statute pretty much in all 50 of the states and federal court. You need to bring forward witnesses with knowledge, and it's got to be a full defense if the defendant is not testifying. So I always thought that that was probably going to get denied. Judge Hippler did. The partial alibi defense that was raised in Latah County was denied by Judge Hippler, but he left open the door that at any time, going to Kayfabe's question, there could be another alibi defense. What the court's order said, and that was in the motion, another in limine motion, in limine pretrial motion for a court order. Mr. Kohberger, if you have another alibi defense that you believe fulfills the requirements of the statutes and the rules, come back, but you got to do it within a reasonable amount of time. So, Kayfabe, we may be seeing another alibi defense. Who knows? Who knows? So, Sarah, no, nothing on the docket as of yet. Now, why would the clerk of court not include the name of the filing party? My suspicious mind is on overload. It might be to maybe, oh boy, here's the offers of proof. We're probably going to get 1,000 phone calls and emails from people wanting to know about it. Or it could have just accidentally happened. I don't know. I have no inside information other than what I'm seeing. But again, that notice of compliance was filed the same day that the defense filed their second set of jury instructions that were due back in March, same day that the offers of proof for the alibi defense was due. Any other questions? I'd like to know who you think the defense. I have no idea. All I know is they have to provide evidence. They have to provide either circumstantial or direct evidence. That's all over the State versus Meister case. That is what Judge Hippler reminded the defense, even saying, even if you're going to look at people that were cleared before, you have to, and you guys know what the difference is between circumstantial and direct evidence is, because that's a question I got from one of my followers of the podcast. The podcast goes all over the world. It's on a bunch of different platforms. I think that the best source is here on YouTube to watch the past episodes if you're interested. One of my listeners from overseas, time difference, couldn't be here today, probably not going to be able to watch very much of the final pretrial conferences. What the heck is circumstantial? What the heck is direct evidence? Well, one of the ways that we were taught in law school was, think about, all right, you're working, you work a night shift. You work at a factory somewhere, the 11 to 7 shift. You come home, you're tired, sun's coming up, beautiful day. You go to sleep and you sleep for about 3 or 4 hours. You wake up and you look outside and the ground's all wet, the cars are wet. You see, that hole in the street you're trying to get the city to fix, that one's got a big puddle in it. People are walking around with closed umbrellas. You don't have direct knowledge. You didn't see it, but it's logical guess, circumstance, that it rained when you were asleep. And that's what caused what you're seeing now, versus you were up all day. You were outside. All of a sudden it thunders. Boom, here comes the rain. People are scurrying inside. Then you have direct actual knowledge that it rained. It sort of operates like that. I have a couple of episodes on YouTube discussing what the jury instruction is regarding direct versus circumstantial and reasonable doubt. Any other very clear link to click? Okay, I should have been thinking that. On the link we're going to use, yes, I would go, and I'm going to end this in just a couple minutes because I want to head over myself. Go to Idaho cases of interest, plug it in, use a couple of different search engines. For some reason, Chrome is the most effective for me. Sometimes when I go on other search engines, it won't let me in. Idaho cases of interest. It's going to take you to the Idaho Supreme Court, the Judicial Branch website. It will have on there the Daybill case, a couple of other cases. Idaho versus Kohberger is usually at the bottom because those other cases are on appeal. Idaho versus Kohberger is still in pretrial right now. Click on the link for Idaho versus Kohberger, and bam, the very first hot link you're going to see is live, watch live hearings here. You click on that and you go over to the 4th district, and then it should come on. I noted the other day they were live on there on the 13th in the afternoon because it said Idaho versus Kohberger. They typically do that a day or two ahead of time to check and make sure the link's working. Any other questions? I was making sure because it's not it's not working yet, Yvonne. Yvonne, let us know when it's on. We'll just keep talking. If there's, I want to also, what I'm hopeful for is that somebody's going to raise what happened this past week. For 2.5 years, we were told all evidence is under seal. There was a non-dissemination order. By the way, it was discussed by Judge in the change of venue order that the parties, Mr. Thompson and Ms. Taylor, stipulated to it, agreed that there should be a non-dissemination order, aka a gag order. Judge hated that term, but it is what it is. It was signed January 3rd, 2023. There was an amended gag order that was signed, or amended non-dissemination order that was signed in January of 2023, later in the month. And then Judge signed another amended, but it's been in place. And, and during that time, we saw the media coalition go to the Supreme Court of Idaho to try to get that gag order set aside. No luck there. Told you got to go down to the district court. Judge denied that. Judge, a year later plus, in the change of venue order, talked about that non-dissemination order being in place to protect Mr. Kohberger's due process privileges, right to a fair trial. That's Judge's words, not mine. Fast forward now, we've had people up until May 7th go in and try to get documents from this case. They've all been told no. And then a day later, we start seeing and hearing that mass media has gotten a hold of evidence, not talking, but evidence, video of suspect vehicle 1. We've never seen video of suspect vehicle 1, not through the official court records. Documents from the 8458 phone, searches of what he was supposedly searching on the 8458 phone. When the 8458 phone was taken from him December 30th, it is item number 11 on the inventory, Commonwealth of Pennsylvania versus Kohberger. That was the case that got opened because he was arrested in another jurisdiction. He was not arrested in Idaho. That's why Detective Payne had to fly out there, right? So if his phone's taken away at the time of arrest, who and how did the mass media get a hold of all this evidence that we have been told? And I have not been a fan of that gag order or all of the items that are listed under seal, but it's in effect. And if we're going to have a judicial system that operates the way it's supposed to be in a democratic society, we got to respect those orders, not decide we're going to go rogue and drop this stuff. They're saying that it was sources close to law enforcement. We don't know. It could have gone to 5 different people. It could have been surreptitiously taken, then dropped in the media's lap. It could have been the defense. It could have been the state. We don't know, but we got a problem because this has gone all over the place. Mass media means it's not 500 followers or 2,000 followers of a YouTube channel. It is multiple millions of followers, including in Ada County. So now what's the impact on the jury pool? Well, according to Shepard, that's Sam Shepard's case, the one wrote about it, blogged about it a couple of days ago. Supreme Court says, you got to be cautious that there's not a lot of, pretrial publicity that's usually going to be negative. You got to do something about it to protect the defendant's due process privileges. And there was supposedly a confession from Sam Shepard. This was the topic of the 1993 movie, The Fugitive, starring Harrison Ford. Great movie, very loosely based on his life. So Supreme Court said, you didn't do enough about pretrial publicity, Judge. You know what? We're going to vacate this order, this jury trial verdict, finding him guilty, and you're going to give him another trial. Second trial, he was acquitted. He only lived 4 years, unfortunately, after that acquittal came down. But I'd like to see Judge Hippler address this today. I looked at this amended non-dissemination order that came out yesterday, late in the day. There was not a dissemination order, the order regarding governing courtroom behavior. He put one into effect back in September after change of venue. Why is he deciding to put one in effect right now? And oh, by the way, very strong words to the media. You will not take photographs. You will not videotape. The only video of the proceedings is through the YouTube channel. And oh, by the way, if any member of the media from XYZ radio or TV station violates anything, you're all gone. All your colleagues, you're out of here, and you may be permanently banned. I mean, it was a lot of strong words from Hippler in that. He's threatening trespassing, possibly putting people on notice, trespassing, contempt of court. He didn't say that about people that wear, inappropriate attire is defined in that order that, hey, if you come in with 3 people, you're not all 3 of you gone. It's just the person who is deemed possibly to be sending political messages or other messages. So I saw that as coming down hard on the media. I'm very interested to see if he addresses what happened this past week. Yvonne, we don't know all of the evidence. Right. We don't know all of the evidence. Hopefully it won't be too late. I was making sure because it's Yvonne, is it still not working yet? Okay. Yeah, it seems like they're not up and running. Maybe they went into closed session. They did that last time. Remember, Kay? I know you remember 9 o'clock in the morning when that marathon day of hearings on the in limine motions. Not the in limine, the suppression motions back in January. They started off in closed session at 9 o'clock, and then they went into open session later on in the day. So possible that they're just running a few minutes late. Possible they went into closed session. I haven't received any notifications, and I'm getting it still offline. We don't know if the evidence. Yeah, we don't know. We don't know the evidence, Yvonne. Not just the gag order, but it's also all of these things that have been signed, to be under seal, i.e., the jury instructions. Nowhere does Judge Hippler say in this October 9th, 2024 pretrial and trial order that the jury instructions are supposed to be under seal. Both sides decided that they wanted to file them under seal, and the court agreed. That's the only reason why the jury instructions are under seal. You look at that order, you're going to see exhibit lister filed under seal. You're going to see witness lister to be filed under seal. You're going to see proposed questions for the jury questionnaire that's going to be going out sometime within the next 78 days, date unknown, because that's redacted from the October 9th order, but not the jury. And guess what else? The trial briefs. Trial briefs weren't supposed to be filed under seal, but they were. You know what the trial briefs are? It's typically the defense saying, this is our opinion on the main issues in this case. Here's the evidence. Here's the legal authority. And prosecution, Here's what we see the case to be. So if the prosecution's case in the trial brief, if that's what's in it, is under seal, who has the right to go out and tell someone what they believe the evidence that the state of Idaho will be presenting when they signed? That's Mr. Thompson. He's lead prosecutor. He still has jurisdiction over this case, even though it's no longer in Ada County, and he signed it. He went with the defense counsel, Ms. Taylor, January 3rd, and said, we need good faith, we need. And then all of the other things, all the 22 supplemental requests for discovery, responses to the discovery, jury instructions, trial briefs, lay witnesses, the people who, not just the expert witnesses, lay witnesses, the people who both sides feel saw. Remember when we said direct evidence before? It's what a lay witness has. Lay witness saw something, heard something, experienced something, knows something of relevance to the 5 claims against counts against Mr. Kohberger. Under seal, we don't know who they are. Probably the authors of proof are going to be under seal too. But going back to pretrial publicity, Judge, I invite you, please look at the September 6th order changing venue, because Judge goes into the fact that the only reason why this case is no longer in Latah County, and the state fought very hard to keep it there. Ingrid Beatty, she did a great job, I thought, getting up and fighting in favor of keeping the case in Latah County. It would have afforded the jury right in the own community where it happened, would have afforded the jury. I know the house isn't there, but they could have maybe taken a trip over together in a bus to see the 1122 neighborhood. They can't do that. People got to drive hours away, fly to be in Ada County because of negative pretrial publicity. Did anyone think any of this publicity that's come out this past week was positive to Mr. Kohberger? I didn't hear one time Mr. Kohberger is construed not guilty under the eyes of the law until or unless he's adjudicated guilty. Now, I know that some people have said, oh, that's a green car. It's a green car under light. But I would venture to say that most people would look at that and say it was very negative to Mr. Kohberger. So what's it being dropped now when we have the trier of the law who decided that things should stay under seal for the reasons that the state and the defense went? They said to protect privacy, to protect Mr. Kohberger's rights to a fair trial, to protect the state's rights to a fair trial so that they are not prejudiced by stuff that's out there, to protect life and safety of unnamed individuals. These were the reasons that were given. I know because I've looked at every item on that docket over the course of the past, couple of years. And so somebody decides that they're going to override this entire process. It's not going to be what's shown to these 12 triers of fact, the future jury. They're going to be instructed. You have to just focus on what's in the courtroom. But if they've seen or heard something, might something have maybe impacted them deep down that they may not even be aware of? Also in that order changing venue, the experts remember Dr. Middleman? He went out there and he did these surveys, including of Ada County. A lot of people in Ada County told him they felt that Mr. Kohberger was guilty. He was most likely guilty. He was definitely guilty. So now, if exposed to this, that's the jury pool. The jury's going to be pulled from the voter registration logs and the driver's license logs in the 4th Judicial District, Ada County. That's where they're coming from. These are the 12 people that are going to have capital case, this man's hands in their face, and then to make sure that justice is being served for the 4 precious lives. Xana, Ethan, Maddie, and Kaylee, who were taken, 20 and 21 years of age in just a minute, and all of the suffering that's left, the whole, that's in their hands. And they're going to more than likely than not be instructed. There's a jury instruction. And okay, Faye, you commented on it. I think you read it. For voir dire, okay, where the judge would turn and say, this is standard jury instruction approved by the Idaho Supreme Court up on the Idaho Supreme Court's website that says, okay, ladies and gentlemen, during voir dire, not just during the trial, but during voir dire, during your break or your lunch break, whatever it is, do not look at anything online. Do not discuss anything. Don't do any research. Don't go on Twitter. Don't look, research anything. You are to focus only on the admissible evidence that's brought in this courtroom. That's it. And so now we've got this piece here. So we'll see if Hippler addresses it today. I'm very, very curious to see if he will. Any other questions? And now YouTubers are showing BK alleged past history. Right. And what about the coworker who supposedly had a crush on him? How embarrassing. I mean, for any woman, you have a crush on a guy. Oh, he rejected you. And this is a coworker. You're not supposed to do that at work either. And so they've named her. They've gone out and said, oh, well, I didn't see where she ever filed. He was arrested for burglary. I never saw that. Where's that coming from? It's just, this is bad idea. If Mr. Kohberger is responsible for this, and we don't know, it's really not our opinion. It's those 12 people in the box who are going to have to make that determination. Then yes, I believe that he should be held to the highest extent of the law. But he deserves a fair trial. And the orders that have been put in place in this case demand respect. They warrant respect. You don't go out and decide you're going to go rogue. Whoever you are, it could be, as I said, it could be purely for money. I don't know if this organization pays, but nobody else had this evidence. It had to be extremely valuable. Sometimes people do this purely for money. They don't care. They don't care about, anything. It's write me a check. Could have been that. Could have been somebody from the defense's side. Oh boy, we're getting all these orders signed against us. Not saying that the lead attorneys, I mean, they know what they're obligated to do under the rules of the Idaho bar that allows them to practice in the state of Idaho. But it might be somebody who got a hold of something, or somebody that was doing maintenance on. This is how stuff gets out. This didn't happen in the Stone Ages. I mean, like 20 or 30 years ago, when you filed everything physically. Now it's just a couple of buttons, and stuff can get from the court files to somebody that shouldn't have it. But they do have it. Now, we have to say alleged evidence because nobody said if this is actual evidence. But it's, they're saying it is, and it seems to look like the video from, we have still images of suspect vehicle 1 that were produced in the in limine briefings. So I hope Judge Hippler addresses this today. I don't think anyone should be allowed to write a book. Oh, yes. Yvonne talking about the books. There are books out there, that people have written. They have already convicted him. Years ago, a lot of people used to do true crime books. I don't know if you know Ann Rule. She was a colleague of Ted Bundy's, and she wrote the book The Stranger Beside Me, but she waited until after he was convicted until she wrote that. She attended the trial. The trial was in Miami. The venue was moved in Florida because of all the negative pretrial publicity. He represented himself. He was guilty. He was found guilty by the jury and sentenced to the DP, and the DP was carried out in the name of Kimberly Leach, not the students who were unalived in the dorm. It was Kimberly Leach. She was like a 12-year-old child that he was convicted of, and he was sent. And was only after that Ann Rule put a book out, and some of the other well-known people that put out true crime books. They waited till after trial is done. What's this? Oh, this is all speculation. This is a novel. This is supposed to be, I mean, even in True Blood, which is probably the first true crime case going back to Truman Capote in the 60s, he waited. They were already convicted. That's when he put the book out in the late 60s. So it says court will begin soon. Okay, guys, when we get that notification that court will begin soon, that's telling us that they're going to get ready to start. So we'll probably do something. I don't know if it'll be today, if tomorrow, if it goes 2 days, or this weekend after the event, but I'll put out some content. I want to thank you. If you haven't subscribed to the channel, thank you. Yvonne, thank you for being, your subscription to the channel. Please you leave your comments, share the information. We're going to be in trial before you know it, if this would happen doesn't get it delayed, which is a possibility too. Okay, everybody. Thank you. We'll be in touch again. Thanks so much. Talk to you soon.